I want to make sure I got that in the video. This is from the AFA Journal, a publication of American Family Association. And this is in, when did I print that? 2015. We got so much problems going on with the Supreme Court of the United States of America that I just figured it was pertinent enough to get something up here so you can see what the hell has happened to the Supreme Court in the last, say, 100 and some years. Sir William Blackstone in the long war against law. In his office in the Alabama Judicial Building, Alabama Supreme Court Justice Tom Parker proudly displays his 4-volume 1773 edition of Commentaries on the Law of England. Written by William Blackstone, the famous English jurist, commentaries form the core of American jurisprudence before and after the ratification of the United States Constitution. Parker, who was elected to the High Court in Alabama in 2004, and he was re-elected 6 years later. An introduction to the reprint from An introduction in the reprint from the University of Chicago Press begins with a startling sentence. Sir William Blackstone's Commentaries on the Law of England, 1765 to 1769, is the most important legal thesis ever written in the English language. In fact, according to a monumental 10-year study conducted by the University of Houston, Blackstone was the third on the list of most quoted sources. Only the Bible represented 34% of cited sources. Here's what you have. What Blackstone was doing here was the primacy of natural law. While Blackstone's books were the foundation of American law when the nation was established, the process of hollowing out Blackstone's influence began almost 150 years ago. Why did this happen? Well, the short answer to that is Blackstone was rejected because Blackstone's ideas were rooted in Judeo-Christian view of the world. Hang in here, people, because I've got to come back here and I put this on PDF so it'd be easier to see. Those laws, let's say, God designed the world to express certain ideas and operate under certain laws. And this theory is called natural law. The influence of Blackstone and other thinkers of a similar vein led to the familiar founding sentiment, such as the mention of the laws of nature and nature's God in the Declaration of Independence. These laws apply to all humanity as well, said Parker. When he created man and imbued him with a free will to conduct himself in all parts of life, he also laid down certain immutable laws of nature, of human nature. He said in an interview with the AFA Journal, in addition, in creating mankind, God also gave him the faculty of reason to discover the purpose of those laws. Human laws are therefore the product of people who comprehend God's purpose in fashioning their own regulation of human conduct to reflect the divine will. However, sorry people, I got this thing all kind of screwed up for you. I was really hoping this would get bigger, but following the end of the Civil War, however, some influential individuals embraced a new idea, Darwinism. The Origin of Species, published by Charles Darwin in 1859, had a huge impact on the movers and shakers who saw no room in American jurisprudence for Blackstone's God-based view of nature. So, there was really a deliberate effort by the president of Harvard University, Charles Eliot, to change things, to introduce evolution into the teaching of law. So he hired Christopher Langdale as dean of Harvard Law School from 1870 to 1895, who changed from using Blackstone's commentary that had these immutable principles to a case law approach, studying the writing of judges. This began the process of changing American jurisprudence, a process, while admittedly was slow, eventually succeeded over all these following decades. Here's what they did, people. What they were able to do was to change the focus of God, who gave immutable principles, to the judge, the man who was writing the law. By studying cases over time, they were able to show an evolution of the law. Further advances of the Darwin impulse in law came with the influence of the late U.S. Supreme Court Justice Oliver Wendell Holmes. Yeah, he really screwed things up good time, people. I kid you not. We'll get to this. Just hang on. We got some real good stuff coming up, and I want you to stick with me on this so you understand why our Supreme Court is all screwed up. It is astounding how long he was here. He served 30 years, from 1902 until he retired in 1932. It was a long career. It enabled him to have quite an impact on the law when his ideas tickled the fancy of so many out there who were ready to embrace it. Holmes is perhaps best known for The Path of Law, an article that appeared in the Harvard Law Review in 1897. In that article, Holmes said, "I often doubt whether it would not be a gain if every word of moral significance could be banished from the law altogether. In other words, adopt different ideas." Throughout this infamous article, Holmes made a complete break from Blackstone and from the past. Morality was separated from jurisprudence. Human expertise and reason were divorced from natural law, and obviously from nature's God. Absolute truth was denied, and the responsibility for determining truth was placed firmly in the hands of judges. Holmes' article had very far-reaching effects. At that point in time in American history, when the laws really pivoted, it changed. From that point on, judges began to accrue power in the American political experiment. Now, this is a very important two sentences here I want you to really stick out in your head so you understand what is wrong with our court. Judge Parker is saying, in my constitutional law classes at Vanderbilt University, one of the better law schools in the country, we never read the Constitution, Parker said. We only read what the judges said about it. Now remember, this is somebody going to school of higher learning, and that's what they did. Now, I want you to get on this. It should not surprise us, as there is no absolute truth in a universal sense. Why should there be any consideration given by judges to the original intent of the architects of the Constitution? Judicial activism soon became common because judges became a law unto themselves. You remember when I told you that these people are going to school to learn to be constitutional lawyers? They don't study the Constitution. They only study what other judges said about the Constitution, thus making that judge the law and not the Constitution. While an ideological alien to the Founding Fathers has clearly taken root, it also changed many fundamentals in jurisprudence and elsewhere. He said the shift began about 35 years ago in a kind of a counterculture movement with American jurisprudence. Hang in there, people. We've got one more to go. Almost done. But I want you people to remember that. It was an obvious move by the Holy Spirit through the legal community in the late 1970s and early 1980s. Lawyers across the country simultaneously were filing these lawsuits in defense of religious liberties. There was no coordination between them. Out of the movement arose a new generation of legal defense groups such as the American Center for Law and Justice, the Liberty Council, Alliance of Defending Freedom, the Liberty Institute, Pacific Justice Institute, and others. Christian law schools began cropping up, those like Regent University, Liberty University, and elsewhere. Now, this group of lawyers who were moved by the Holy Spirit took action and created institutions that will have a long-reaching effect. The legal training being provided through these Christian law schools gives everybody hopes. They have brilliant legal scholars, and they come out of these law schools. We have some leading intellectual light in the Christian jurisprudence. Simultaneously, Parker noted that the important work of a new generation of cultural-minded Christians. These powerful groups like the AFA, founded in 1977 by Reverend Don Willman, were created to inform and equip believers and other social conservatives to engage in the critical issues of the day. While many Christians have seen the need to return to the founding principles of law, there remains a large percentage of the Christian community that is still involved in politics and culture. This causes expiration. It's very frustrating for those who attempt to bury their heads in the sand and not see the role in contriving or striving for the truth. Darwin activists like Langdale and Holmes commenced the process of overturning the founding principles and refashioning American jurisprudence. All this was done without once asking for the permission of the citizens of whom the new laws would rule. People who love the founding fathers and the bedrock principles of America should at least fight back against this process and try to reverse it. I've been wanting to get people aware of this happening for quite some time. I'm going to go back here just a minute to this because I want this. Like I said, judges began to accrue power from Langdale being down here in Harvard. Like I said here, let's get this down here a little bit more. In my constitutional law classes at Vanderbilt University, one of the better law schools in the country, we never read the Constitution, just what judges said about it. Now this should not surprise us. There's no absolute truth in a universal sense. Why should there be any consideration given by judges to the original intent of the architects of the Constitution? Well, depends on who's doing the judging. Judicial activism became common because judges became a law unto themselves. They never read the Constitution. They only read what other judges said about it. Like I said, when you don't study the Constitution, the Declaration of Independence, the Federalist Papers, the Anti-Federalist Papers, you don't have nothing to base anything on. Just because a judge said this about a law or said that about a law, he can be ill-informed. He might have some kind of a political agenda. You've got to go by the original documents. You cannot interpret the Constitution except as the way it was written back in 1776. You've got to get all that stuff all gathered up from that time, well actually before that time, up until 1791. You've got to put that stuff together before you make a rational decision on how the Constitution should be interpreted. If you cannot read the Declaration of Independence, if you haven't read the Federalist Papers, you don't know what you're talking about. How many of you even read the Constitution? That's another thorn in the side. And you're up there trying to pass your interpretations of how you think onto the people of the United States of America. You're not justified in doing that. Thanks for watching.